Okay. Can you hear me, Mr. Stern?
Yes, I can, Your Honor.
And I take it you are Timothy Stern.
Yes, yes, sir.
All right, if I could get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God?
I do.
Okay, Mr. Stern, I'm gonna do this in the interest of brevity. I'm gonna, since I have the original, or what purports to be the original of your father's will, I'm gonna hold up the last will and testament of Alan D. Stern. Do you recognize that as being his will?
Yes, Your Honor, I do.
Okay, and I'm gonna go back to the signature page. And if you recognize that as being his signature on that document.
That is his signature. Yes, Your Honor.
Okay, and to your knowledge, after the date he executed this will, which appears to have been done on the 7th day of December of the year 2000, did he ever amend it or revoke it?
No further, no amendments or revocations.
Okay, go right ahead, Mr. Frazier.
Okay. Tim, could you state your name for the judge?
My name's Timothy Lee Sturm.
Okay. And Alan D. Sturm is your dad?
Yes,
And then he died on February 17th, 2023 in Jefferson County, Texas at the age of 85 years. Is that all correct?
that's correct.
Okay. And he was domiciled and had a fixed place of residence in Jefferson County at the time of his death. Is that correct?
Yes, that's also correct.
Okay. And the will that the judge just showed you, that's never revoked. Is that correct?
Never revoked.
Okay. There is a need for administration of the estate. Is that correct? Did you get letters?
Yes, there's a need for that, for
Okay.
sure.
And is it true that after the date of the will, there were no children born to or adopted by your dad?
That's correct also.
Okay. And after the date of the will, no marriage was ever dissolved. Is that correct?
That's also correct.
Okay. And in the will, you're named to serve as independent executive, serve without bond as independent executor. As far as you know, you're qualified to serve. You're not disqualified for any reason, and you're entitled to letters. Is that all correct?
Yes, I am qualified to serve, and I am named in the will.
Okay. All right. Your Honor, that's all the testimony
Okay.
I had. I'll
Mr.
pass it on.
Stern, you've been provided with a document called Proof of Death and Other Facts.
I have been.
Have you read that?
I have.
Is everything in there true and correct and within your personal knowledge?
Everything in there is true and correct, and in my personal knowledge, yes.
Okay, so if you will make arrangements to sign that before a notary public, return that along with your oath of independent executor, also signed, executed, notarized, just as your name is typed on there. So it's going to be the Timothy Lee. And he will e-file those with the county clerk. Once he does that, I will sign the order admitting your father's will to probate and authorizing the county clerk to issue letters testamentary that will give you authority to act on behalf of the estate. Within 90 days of the date I sign the order, please cooperate with your attorney in getting him a listing of or an inventory of the estate, because he has 90 days from the date of the order under the Texas Estate Code to file an inventory with the court. So if you'll handle that expeditiously, that would be greatly appreciated.
Of course, Your Honor, I'd be happy to.
I hope everything goes really well, and let us know if you need anything.
Okay.
Y'all have a
Thank you very
great week.
much.
Thank you very much, Your Honor.
Take care.
Thank you.
Okay. Bye.
All righty, let's see here. Mr. Dowden or Mr. Mayo?
That Aaron Matthews on that list? Here, yes. This is not showing up on here. Okay. We have.
Hey, Judge, can you hear me?
I can hear you.
Good, good.
I must be at this.
Rhoda DeVette Goodman.
Let's see who this is. Can't see that. I don't know. Got that already.
Now what happened? Your host has asked you to start your video, so start my video.
Yeah.
I'm sure I could do that myself, but.
Damn.
There's Aaron. Hey, Aaron.
Hey, how's it going?
And then I'll go through it, because I have some in that account, so I was making sure I had everything. I'll check. Call me while he's over.
What is all that background noise?
That's Ms. Dowden in here, Judge. Do you need me to bring her in here and have you hold her in contempt of court or something? Because I'll be happy to. Because I can't seem to handle her.
Well, I would, but it's gonna take the sheriff too long to get down there.
I know.
We'll just forget about it today.
Good to see you.
Okay, let's see. You are Aaron Wayne Matthews?
Yes, Judge.
Okay, Mr. Matthews, if you'll raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God?
I swear. Yes, sir.
Okay, Mr. Matthews, I'm gonna hold up what purports to be the last will and testament of Rhoda Devette Goodman. Do you recognize that as being her will?
Yes, sir.
And I'm gonna go back to the signature page. And are you familiar with her signature?
Yes, sir.
Is that her signature on that document?
Yes, sir.
And to your knowledge, after the date she made this will, which is said to be September 26th of 2022, did she ever change it or revoke it?
No, sir.
Okay, go right ahead, Mr. Dowden.
Thank you, Judge. You're Aaron Wayne Matthews. Is that true?
Yes, sir.
And here today about the estate of your mom, Rhoda DeVette Goodman. Is that true?
Yes, sir.
And we've sent over to you, Aaron, a proof of death and other facts, and for you to execute in front of a notary and return to us for filing. And have you had a chance to look over that document?
Yes, sir.
And is everything in there, in that document, within your knowledge and true and correct?
Yes, sir.
Okay, we also sent you an oath where you promised Judge Brannick that you'll take care of the affairs of your mom's estate to the best of your abilities. Have you received that document and reviewed it?
Yes, sir.
And you promised the court you'll take care of her affairs, is that right?
Yes, sir.
I think we just about 10 minutes ago sent you an inventory on your mom's estate, and we're going to ask you to sign that and have it notarized, and so we can get that filed with the court. Is that right?
Yes, sir.
And so we're asking the court to admit the will to probate, to appoint you executor of the estate, and then at some appropriate time, we've got a question that we want to present to the judge about a bequest from your mother to your daughter, but we could maybe visit about that in a minute. But right now, for our purposes, admit the will to probate and have letters issued to you. Is that right?
Yes, sir.
Okay, Judge, that's all I have, unless you need anything further.
So what's gonna happen, Mr. Matthews, is you're gonna execute those before a notary public, just as Mr. Dowden said. You're gonna return those to him. He'll e-file those with the clerk. When he does, I'll sign the order admitting your mother's will to probate and authorizing the county clerk to issue letters testamentary. Those letters will give you authority to act on behalf of your mother's estate. Please make sure that you cooperate with Mr. Dowden in getting the inventory done, because the Texas Estates Code requires it to be filed within 90 days. So otherwise, I hope everything goes well, and y'all let us know if you need anything.
Yes, sir.
Judge,
Have a great week. I
Judge,
forget, Mr. Matthews, you live in New Brunswick?
That's correct, sir.
Any rain out there?
It's cloudy. It sprinkled a little bit, but nothing worth writing home to mama about.
Yeah. All right. Well, y'all have a great one. Did you need something else, Mr. Dowden?
well, Judge, just to get your opinion on a question we have on page 2 of the will, you have it, paragraph, 5. Brianna Matthews is Mr. Matthews' daughter, granddaughter of the testator, the decedent. And you'll notice I bequeath and devise the 2009 Honda CRV. I was going to come visit with you, Judge, and ask you, I mean, we can hold that vehicle in a garage. We kind of wish the court would consider, if it's possible, I've never asked anything like this before, to let us maybe sell it and put the money in an interest-bearing account. Mr. Matthews told me
How old is Brianna?
she's
She's 12 years old, sir.
12 years old. We hate for it to
She's
just sit
still
there.
4 years away,
Yes, sir.
during which time the vehicle's going to lose a lot of value.
Yes, sir.
Now, I would actually prefer that it be sold, the money be placed in the registry of the court and then to an interest-bearing account or something.
He's got Aaron, would you tell the judge what you told me a while ago? You've got at Edward Jones, you've got,
So
Tell
I
the
have
court.
2 accounts already established for my daughter. One is a savings holding account, and then the other one is a custodial account that I have for her as well.
but Judge, I told him you may want the funds frozen at Community Bank, and we'll of course defer to you. But
No, I wouldn't have a problem if it went to Edward Jones. I assume he's the trustee. You're the trustee on the custodial account?
Yes, sir.
Yeah, I don't have a problem with that. She's 4 years away from needing a car, at least. She's like the young people now, they put off getting their driver's
it's
license.
true. Yeah.
So, yeah, I wouldn't have a problem if he sold it, as long as she got the value.
Would you want a motion and an order, or would just do it? And
I think you can just do it.
okay.
I would just sell it as executor and place the money in her account and let it stay there until she's at least 18.
Okay, we'll do it. Thank you, Judge.
All right, y'all have a great week.
Appreciate it. Thank
All
you.
right,
Okay, bye-bye.
All right, bye-bye.
Druitt. Mr. Druitt, what are you here on?
Oh, I'm here as a witness, Your Honor.
Oh, okay. Okay, so, on this John Raymond Long, I see it's not self-proven, okay. All right. Are you Kenneth Ray Long?
Yes, sir.
Okay, Mr. Long, if you can hear me okay, if you'll raise your right hand. Do you have your right hand raised?
Yes, sir.
Okay. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth so help you God?
Yes, sir, I do.
Okay, I'll waive the oath for Mr. Druitt as an officer of the court. And I guess to try to expedite it a little bit, I'm gonna show you what purports to be the last will and testament of Mr. John Ray Long. Do you recognize that as being a copy of his will, sir?
Yes, sir.
And I'm gonna go back to the signature page and ask you if you recognize that as being a copy of his signature on this.
Yes, sir. That is my father's signature.
Okay, and that appears that the will was executed on May 10th of 1999. To your knowledge, after the date that that will was made, was it ever changed or revoked other than by the codicil, which was apparently done in 2014?
No, sir.
Okay. I'm now gonna show you what purports to be the first codicil to the will of John Raymond Long. Do you recognize that as being such?
Yes, sir.
I'm also going to go back to the signature page on that document, which appears to be an original, and ask you if that is his signature.
Yes, sir, it is.
Okay. And that appears to have been executed on March 25th, 2014. And to your knowledge, after that date, were any other changes or alterations made to his original will or codicil of 2000 or 1999 and 2014?
No, sir.
Okay. I'll let you, Mr. Mayo, question Mr. Druitt and
Thank you.
take care of proof of death and other facts.
All right, Your Honor. Mr. Druitt, you're licensed to practice law in the state of Texas and has been for some 40 years. Is that correct?
That's correct.
You're board certified elder law attorney by the National Elder Law Foundation. You're board certified in estate and probate law by the Texas Board of Legal Specialization, and you have an LLM with elder law with distinction from Stetson University College of Law. Is that correct?
Yes, sir.
You've seen what we filed in this case, what we entitled the last will and testament, John Raymond Long. Was that a exact duplicate or copy of the document that was prepared in your office on May 10th of 1999?
Yes, it is.
And is it true that you were personally present and you served as a notary, taking the oaths of the testator and the two witnesses when that will was executed?
Yes, sir, I did.
The two witnesses, a Melissa Eggerly and Regina Falcon, were currently at that time were employees of yours and were each of over the age of 14 years at that time. Is that correct?
Yes, it is.
Did Mr. Long sign the will in your presence and the presence of the two witnesses? And did he request that each of the witnesses sign his will as witnesses?
Yes, that is correct.
And did the witnesses sign as witnesses in his presence and the presence of each other and in your presence as the notary?
Yes, they did.
At the time of signing the will, was Mr. Long over the age of 18 years and was he of sound mind?
Yes, he was.
Now, after the will was signed, it was a copy of it was maintained in your office ever since the date that will was signed. Is that correct?
That's correct.
And when I asked you to check your records about this will, you were able to produce a digital copy of the will that's offered here for probate today. Is that correct?
That's correct.
And the provisions of that will are exactly the same as the provisions of the will that you've maintained in your office since the date the will was executed. Is that correct?
That is correct.
Okay. That's all we'd have of this witness, Your Honor.
Okay. Thank you, Mr. Druitt. I appreciate you attending here today. I know you have other things to take care of, so if you need to be excused, you may be excused.
Thank
Okay,
you.
I'll stay on until we're done, just in case.
Okay, if you will, Mr. Mayo, if you want to proceed with Mr. Long on the proof.
All right. Mr. Long, can you please tell the court where you reside?
I reside at 10855 Eagle Drive, Mont Bellevue, Texas, apartment 224, 7523.
All right. And John Raymond Long, the decedent in the matter at bar, was your father. Is that correct?
Yes, sir.
And is it true that he died on September 24th, 2002 at Beaumont, Jefferson County, Texas, at the age of 87 years, and 4 years have not elapsed since the date of his death.
Yes, sir, he did.
Did you say 2002 or 2000?
2022, Your Honor.
Oh,
Did I say
2020
2002?
2022. Yes, sir.
I'm sorry if I misspoke. At the time of his death, he was domiciled and had a fixed place in residence in Jefferson County. Is that correct? Mr.
Yes,
Long?
sir, he did.
Okay. And to the best of your knowledge, the will which we filed, or the copy of the will we filed with the court, and the codicil was never revoked by him. Can you hear me, Mr. Long?
You kind of going in and out. Yes, sir.
The will and the codicil that we presented to the court today, to the best of your knowledge, was never revoked.
No, sir, it was not.
All right. The will and the codicil, neither one, of a state or governmental agency of the state or a charitable organization, is not a devisee in the will or the codicil. Is that correct?
Yes, sir.
Okay. And after the date the will or the codicil was signed, no children were born to or adopted by your father. Is that correct?
I'm sorry, I'm having bad reception, sir.
okay. He said after the date that the will and codicil were executed by your father, no children were born to or adopted by him. Is that correct?
Must be on his end, Your Honor.
Yeah.
Yes, sir. Yes, sir. I'm having,
Okay. Some kind of delay or something going on there.
yes, sir.
Okay. And after that date, he was never divorced. Is that correct?
No, sir, he never was divorced.
Okay. The codicil names you to serve as an independent executor of his estate. Is that correct?
Yes, sir.
Okay. And we've been over the requirements to serve as an independent executor, and you're not disqualified by law from accepting letters of testamentary, and you're entitled to such letters. Is that correct?
No, sir, I'm not.
I'm sorry, Your Honor. He must have some problem on his end, I think.
Yeah,
Yes,
he
sir,
does.
I still am. We had some bad weather earlier.
Okay. Have you read the proof of death and other facts that Mr. Mayo provided to you?
Yes, sir, I have it right here beside me.
Is everything in there true and correct and within your personal knowledge?
Yes, sir, it is.
Okay, Mr. Mayo, if you'll just get him to execute that before a notary, return that with his oath, and we'll get everything taken care of.
We thank you so much, Your Honor. We'd rest.
Y'all have a great week.
All right, thank you, sir.
Thank you,
Thank
gentlemen.
you, Judge.
Bye-bye. Thank you, Your Honor.
Righty, let's see. Is that it?